genuinely. She has spoken to the media on a number of occasions and indicated that she will be speaking after this, and we just think that whatever is stated in court is of great import.
There has been no request and there is no prohibition about her, any audio recording of her testimony. I'm only in control of what's in the courtroom, so, and I've not heard any case law or read of any case law on the waiver issue. But while she's here, I think the victim, and I would grant her request that there be no video capture of her while she's in the courtroom. What she does outside the courtroom, I leave to her and to you.
Thank you.
The objection is timely but overruled. We're ready when you're ready. Yes, ma'am. Please be seated. The record should reflect the presence of Mr. Chrisman and counsel and the jurors. Good afternoon. Each of you should have a set of instructions. I'm going to read most of them at this time. You are welcome to follow along. You have returned a verdict of guilty. Because of that fact, we must conduct a second phase of the trial. The state has alleged an aggravating circumstance in this case. Under Arizona law, the jury must decide whether any aggravating circumstances exist. The law requires the state to prove the specific aggravating circumstances to you beyond a reasonable doubt. Based on that allegation, we are now beginning an aggravating circumstance hearing. Before evidence is presented, you must start with the presumption that the alleged aggravating circumstance is not proven. The state must present evidence to prove an aggravating circumstance beyond a reasonable doubt. If you conclude that the state has not met its burden of proof beyond a reasonable doubt, then you must find the alleged aggravating circumstance not proven. The defendant is not required to testify or produce evidence of any kind. The decision on whether to testify or produce evidence is left to the defendant acting with the advice of an attorney. The defendant's decision not to testify or produce evidence is not evidence of the existence of any aggravating circumstance. It is your duty as a juror to decide this case and by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. You may also rely on the jury instructions that were read and given to you earlier. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and exhibits introduced in court during the earlier trial, as well as any testimony or exhibits introduced at the aggravation circumstance hearing. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel that I have about the facts. You as the jurors are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction and part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. The lawyers will again talk to you about the law and the evidence. What the lawyers say is not evidence, but it may help you understand the law and the evidence. You must decide whether the state has proven an alleged aggravating circumstance by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment in reaching a decision. Punishment is left to the judge. You are determined what the facts in the case are from the evidence produced in court during the trial or the aggravating circumstance hearing. If the court sustains an objection to a lawyer's question, you must disregard it and the answer given. Any testimony stricken from the court record must not be considered. Evidence may be direct or circumstantial. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it's direct or circumstantial. In considering the evidence, you must decide whether to believe the witnesses and their testimony. As you do this, you should consider the testimony in light of all the other evidence in the case. This means you may consider such things as the witness's ability and opportunity to observe, their manner and memory while testifying, any motive or prejudice they might have, and any inconsistent statements they may have made. The state has the burden of proving any aggravating circumstance beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced that the alleged aggravating circumstance is proven. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the alleged aggravating circumstance is proven, you must find that the alleged aggravating circumstance exists. If, on the other hand, you think there is a real possibility that the alleged aggravating circumstance is not proven, you must give the defendant the benefit of the doubt and find the alleged aggravating circumstance not proven. For count 2, aggravated assault, the state has alleged the aggravating circumstance that the aggravated assault of Mr. Rodriguez caused emotional harm to his family members. The balance of the instructions I will read after the evidence has been presented. Mr. Martinez, do you wish to proceed with an opening statement?
No, the state will waive its opening statement.
Mr. Meredith, do you wish to proceed with an opening statement?
Yes, Your Honor.
You may.
Good afternoon. I just want to discuss very briefly with you the law, and it's the last sentence that the judge read to you.
Objection, argument. We're going to discuss the evidence. Overruled.
And it's the last sentence that the judge read from the instruction. The thing we are here today for is to determine whether or not the state can prove beyond a reasonable doubt the aggravating circumstance that the family members suffered emotional harm, and it's only as to the crime for which you found Mr. Chrisman guilty, the aggravated assault, is for nothing else. Thank you.
Mr. Martinez, you may proceed.
State policy, we have no evidence.
Your name, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
It's a hard share. Okay.
Your name, please,
Fernandez.
and drawing your attention back to October of 2010, where we presented.
I was living in
Can you
my
pull these microphones so that
That's right. Pull that close to you.
both those? Where were you living?
on 2010.
In October of 2010.
I was living with my son.
What was the address?
It's 301 East of Mount Avenue, space 51.
And you indicated that you were living there with somebody. Who were you living there with?
With my son, Daniel Rodriguez.
And as it applies to the, at that time, police officer Richard Chrisman putting the gun to his head, did that affect you emotionally?
Yes, it did.
Tell me how.
It's the thought of my son having a gun to his head. It scares me to death. To the point where it consumes me with sadness. That my son would have to go through an ordeal like that.
Do you have anything about the fact that your call was the reason that that gun was put to his head? Anything about that that causes you any emotional harm?
Every day I think about it, it causes me extreme sadness. It consumes me where I can't sleep at night. I can't stop thinking about that day. The program. I don't go anywhere. I don't do anything. I just keep thinking about that day. I mean, that's hard pain.
In terms of any actions that you may contemplate as a result of that gun being put to your son's head, Have you ever contemplated, for example, suicide?
Yes, I've tried to commit suicide twice since then.
And how was it that you attempted to suicide?
Overdose on pills and medication. Right now I'm under medication, but other than that, it's every day I wish I was dead. Everything is with me.
What is Mr. Daniel Rodriguez, what is his father's name?
His name is Frank Rodriguez.
And since this aggravated assault, the gun was pointed to Mr. Rodriguez's head, describe his medical condition from October of 2010 to the present. Any changes?
Yes.
What changes?
He's been very sick and he's not healthy. He's had 2 strokes since then.
And in terms of him going out, does he ever want to go out or not?
So that's one of the reasons he didn't want to be here, because his face is twisting once in one side because of his stroke.
I don't have any questions. Thank you.
Mr. Marion?
I'm sorry, Judge. We take a small short recess. I think we need to.
Okay, ladies and gentlemen, so that the lawyers can get an exhibit. If you go back to the jury room, please remember the admonition. You haven't heard all the evidence. I'm response to these questions. So we'll bring you back.